So, former President Zuma will tomorrow be asking for an interdict to stop his arrest. The police have until Wednesday midnight to arrest him and take him to prison, following his decision not to present himself at a police station within the 5 days given to him to report following the Constitutional Court decision last week. Now, that application will be made in Pietermaritzburg tomorrow. The State Capture Commission and the Helen Suzman Foundation are opposing. That's the first part. Then next Monday, on the 12th of July, the Constitutional Court will hear his attempt to get a rescission of the order. Let's discuss this all now with Anton van Dalsen, legal counsellor at the Helen Suzman Foundation. Mr. Dalsen, thank you so much for your time. So it's to the High Court to try and stop the arrest tomorrow. Then the next step will be Constitutional Court next Monday, and hopefully to get a rescission of the imprisonment order or overturn the judgment, essentially. What is this jurisdiction problem that Karen alluded to in the piece we've just played? And is that the main issue that that tomorrow's court hearing will focus on?
I think it is. I didn't hear the comments by Karen just now, but I can guess what they were. The jurisdictional issue is really whether a High Court in Pietermaritzburg is able to suspend an order of a higher court, in this case the Constitutional Court. And generally speaking, the answer is no. It's quite obvious that a lower court cannot mess around with judgments of higher courts, because that would lead to judicial chaos. So it's very odd to us that this attempt is being launched in the Pietermaritzburg court, and with a request effectively to suspend the Constitutional Court's order.
All right, so the other thing I wanted to ask is, this is an urgent application. Urgent because obviously the former president doesn't want to be arrested after the deadline. You know, the police have until the end of Wednesday to arrest him. If he is, yes. if he fails tomorrow, I'm wondering how urgent the decision. First of all, how urgent is urgent? Will the High Court be mindful that they have to make a decision within the next 2 days, or could they take their time?
I think they'd be very mindful of it. Of course, there is the option of giving the decision and then to say reasons will follow later. That's one way of dealing with these things. But I think they would be very aware of the fact that an urgent decision is in the circumstances, is very necessary. If
the court makes an urgent decision, let's say tomorrow, that he has not been successful in getting a stay of execution of the arrest, does that mean that he will go to prison in the meantime, and then next Monday the Constitutional Court will then look at the rescission application?
Well, the thing is that if the court tomorrow in Pietermaritzburg declines to take any action, that means that the Constitutional Court's order stands, and that Constitutional Court order, as you mentioned just now, requires the Minister of Police to arrest Mr. Zuma 3 days after the 5 days have expired. Now, the police minister cannot on his own decide not to do that. So that court order stands unless the police approach the Constitutional Court for an amendment of that order.
So there's a political party that is already saying that the former president needs a pardon, a political pardon, which can only come from the president. In terms of how that works, obviously that's a political decision, but is that something that can be granted before he's actually gone to prison?
Well, what is the suggestion that he be pardoned for?
For contempt of court.
Oh, for contempt of court. I thought, yeah. I mean, it's possible, but I do not see this happening. You know, it's something which has not been raised in serious discussions up to now. Mm-hmm. I do not see that happening. I think the court process will first have to run its course, and then after that has happened, we will see what may transpire from that.
Talk to me about this rescission application, which the Constitutional Court agreed over the weekend to hear. And obviously that will be heard on the 12th of July, which is next Monday. You have joined forces with the State Capture Commission, which signalled over the weekend you'd be challenging that. Talk to me first about what rescission is exactly, because we are in many ways in uncharted territory, and I get a sense, are we going to see precedents made in this particular case, potentially?
Yeah, I mean, just to start off with, I don't think it's correct to say we've joined forces with the State Capture Commission. We do have our own counsel and our own opinions and our own arguments that we're putting forward. Mm-hmm. But to get back to the rescission question, there are provisions in the Uniform Rules of Court which allow courts to proceed to rescission of a judgment. But the grounds on which, or the circumstances in which such a rescission could be granted are very, very closely defined and very limited. Effectively, they boil down to a very basic, obvious error in the judgment. And this would usually be a factual error. It also provides for a case where there was a common fault or common mistake made by the two parties, which obviously isn't the case here. And also where judgment is given in the absence of one party, which wouldn't apply here either, because the one party, being Mr. Zuma, decided not to take part in the proceedings. And if you look at the grounds on which the actual grounds on which a rescission can be granted, these would be basic errors, and we're not talking fine legal arguments here. So I do not see the grounds for a rescission in the application.
So the former president said over the weekend that going to prison is like a death sentence for him because he's got comorbidities, he's elderly, and he hasn't been vaccinated. Can that be used in any way legal, in your opinion?
It's very difficult. I mean, but I think the point needs to be made. Up to now, Mr. Zuma has been very clear that he didn't want to participate in the court proceedings. He wasn't scared of going to jail and so on. And now, since the decision of the Constitutional Court a week ago, suddenly his health issues come to the fore. So in many ways, you know, there was a lot of bravado on his part, and he's changed his tune all of a sudden. So I think, you know, courts will also take that into account. It's not been a concern up to now. It's only been raised in the last day or two.
Why is it important for the Helen Suzman Foundation to be involved in this part of the process? Why is it crucial? Why are the stakes so high, in your opinion?
Well, just to explain how we got involved, we were a friend of the court, or amicus curiae, in the original discussion in the Constitutional Court. And we applied to join as a friend of the court because we felt we could assist the court, because there was only one applicant and no respondent. Mr. Zuma declined to take part. And it was the the Commission of the State Inquiry into State Capture, which was the only applicant, and they asked for a 2-year jail sentence. And we felt it would be useful for the Constitutional Court to get a broader view of what is possible in these circumstances and what might be appropriate sentences. We did that, and from the judgment of the Constitutional Court, it was obvious that they found it useful. Now, in this, the case which is appearing tomorrow and the one on Monday, we have been cited by Mr. Zuma as a respondent. So we've gone from being a friend of the court to being a respondent. But we have not asked to be a respondent. But since we are a respondent in this case, we felt, given our focus on the importance of the rule of law in a constitutional democracy, that there were certain aspects that we needed to highlight and emphasize.
All right, well, thank you so much for joining us this evening. Much appreciated. Anton van Dalsen, legal counsellor at the Helen Suzman Foundation.